It's a great privilege for me to introduce Justice Peter Lauwers. Of course, all members of the Canadian judiciary are amazing, but I'm a fan of a few of them. Last year at the Runnymede event, I got to introduce David Stratus. I'm a big fan, and I'm a huge fan of Justice Lauwers. Justice Lauwers, as many of you probably saw from the promotion of her materials, was a civil litigator for many years. He was called to the bar in 1980. He attended 2 universities in Toronto. Can't remember the names of those. Unimportant universities. Not McGill. He didn't attend McGill. Although I see from his biographical notes that he's taught here a couple of times, I think. Is that right? Yeah. So, worth listening to, certainly. And he was called to the bar in 1980 and to the Superior Court of Ontario in 2008. And then he was elevated to the Court of Appeal in 2012. He has appeared before all levels of courts in Canada, including the Supreme Court, on a number of important constitutional questions with respect to education rights. And he was also, I noticed, involved in same-sex marriage reference. Now, I don't want to go in any further with I know you all want to hear from Justice Lauwers. I just wanted to mention that the subject of today's discussion on the judicial review of charter rights, in particular the role that charter values plays, is a subject of enormous importance. Many of you know that I'm a lawyer for the Attorney General of Canada, and my view is that this approach that the court has followed since the decision in Doré is one that makes my job easier. It's easier to justify the infringement of charter rights, in my view, in an analysis that focuses primarily on charter values rather than charter rights. So I make no value judgment. If you think it's a good thing that it's easier for the government to justify infringements of charter rights, great. And if you don't think so, then this is a subject matter that should be of concern to you. So without any other comment, please welcome Justice Peter Lauwers.
Well, thank you very much for the great turnout. I think it may have more to do with free lunch than it has to do with me. But I'll try to entertain you for the next little while. It's interesting to me that it just occurred to me as I was sitting down this morning, 40 years ago, I graduated from the University of Toronto Law School. 40 years ago. So we're having our reunion next month, and I'm calling it the last waltz. Pretty macabre, I suppose, but just thinking about where you are right now, I was where you were. I remember those days very well. But it's hard for me to imagine from where I stand here what 40 years out from now is going to look like. Very difficult to imagine. So, I think my intuition is this, that the subject that we're talking about today is going to have a very significant impact on what the world looks like in Canada in 40 years from now. That's maybe not, I think that's actually not putting it too highly. So, the title of my talk, I think it was portrayed as something else, is going to be the almost empty idea of charter values. The almost empty idea of charter values. The question of what the idea of charter values might mean for charter rights has preoccupied me for a few years. The title I've given shows my profound ambivalence about the concept. The problem is revealed in the Supreme Court of Canada's decision in Trinity Western University and how it gives force to its decision in Doré. Now, my last foray into this area was the Runnymede lecture in January 2018. If you want to look at that, you can find it on YouTube, looking under the Runnymede Society. Part of that talk opened up the whole question of human cognition in judging. I laid out the recent psychological research that shows the need for constraints around judicial power. I said what our ancestors intuited from observation and experience and passed into law and practice in order to constrain judicial power, psychology now demonstrates as necessary. Perhaps we need rules more than we like to think. I said given the nature of human cognition, discretionary decision-making should be approached with great caution. So that set the scene for my discussion of charter values in that talk, pre-TWU. There's no doubt, as you know, the use of charter values language is prevalent in our culture. People talk about Canadian values, European values, religious values of various stripes, and so on. What do we mean when we use the term values? It has become our ethical keyword, but what do we mean by it? It's not clear. What are charter values? What is a charter value? Where do they come from? Is there anything to the notion that charter values can give rise to new charter rights, whatever the text of the charter actually says? Are charter values legion? As some say is the implication of the Supreme Court's decision in Doré. Consider this ostensibly benign list of charter values extracted from the reported Supreme Court cases: liberty, human dignity, equality, autonomy, fairness, expressive freedom, and privacy. And there are others in the jurisprudence if you take a broad view. The Supreme Court identified a list of cardinal values in Oakes, including respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions which enhance the participation of individuals and groups in society. The court later added autonomy, liberty, equality, and human dignity. One could find others in the Quebec secession reference and elsewhere. Professor Pless says that his class managed to develop a list of about 100 charter values. I'm not surprised. The list is not closed, so there may be some more that come onto it. People argue that diversity and inclusion are charter values. No doubt there are many other possibilities. Some academics have actually urged tribunals to use recognized charter values, or even make up new or novel values according to or analogous to an existing charter value in discretionary decision making. So the problematic next move is to deploy those charter values, even the novel ones, as though they have the same force as charter rights. Can this be the right approach? That was the issue in TWU, and the Supreme Court of Canada said yes. I think that was a mistaken decision, and I think I'll have to walk that back. So let me explain why. There is, of course, no doctrinal definition of what a charter value is. Perhaps it is a concept best understood by watching how it has been used in legal reasoning. The cases have used charter values in 5 different ways. First, in interpreting the charter. Second, in developing the common law. Third, in interpreting statutes. These are, in my view, unproblematic uses of charter values. The problem comes with the next two, and that is reviewing the exercise of discretion in administrative law and engaging in proportionality analysis under Section 1 of the Charter. Now, the Supreme Court of Canada has, in other moments, recognized that charter values analysis should be avoided where it is not necessary. The court's usually cautious approach to the use of charter values is, I think, warranted. In carrying out a purpose of analysis of the scope of a charter right, courts must sometimes go behind the right to consider the human interests that it was meant to serve. As an example, dignity is an important substrate to personal rights. Courts have invoked it from time to time. We can easily imagine other charter values like equality and liberty working in that limited sense. Note Justice Avella's statement in Gombach that the application of charter values, and this is what she said, quote, cannot be used as a freewheeling deus ex machina to subvert clear statutory language or to circumvent the need for direct charter scrutiny with its attendant, calibrated evidentiary and justificatory requirements. That's what she said in Gombach. Strong language, and I agree with it. I ended my January remarks with this worry about a troika. First, the advent of unbridled charter values. Second, the requirement of appellate deference to first-level courts, and especially to administrative tribunals. And third, the increasing resort to proportionality analysis. I worried that this troika could serve to magnify enormously the discretion of administrative decision makers. And that, of course, is precisely what the Supreme Court of Canada did in the TWU decisions. The majority doubled down on the deeply problematic approach that the court took in Doré to the intersection between administrative bodies and the application of the Charter. The majority also explicated the proportionality test in Section 1 of the Charter, I would say in problematic ways. Let me explain. I start with a brief philosophical segue, then look at TWU. So, what is the problem with charter values? The problem is conceptual. The idea of charter values on close examination is an almost empty idea. I use the word almost because I have told you 3 of those different uses of charter values are perfectly appropriate. For example, trying to figure out an interpretation of a charter right. So, listen to a point made by a philosopher, John Dewey, in 1923, long before the use of this word, values, became prevalent. This is what he said. Speaking literally, there are no such things as values. There are things, all sorts of things, having the unique, the experienced, but undefinable quality of value. Values in plural, or a value in the singular, is merely a convenient abbreviation for an object, event, situation, or thing possessing the quality. Discussion of the theory of values in goods, whether moral or aesthetic, manifests a tendency to forget the concrete things to which the value quality is attached. Thus it is said that liking constitutes value. Note that the term value is not primary, but derivative. It's a second-order concept. The value of a thing derives from the thing itself, whether it's a concept or a value or an object, even though it is possible to consider value in the abstract. You can talk about the quality of value, but it is attached to something real. The term value also has a vaguely positive connotation. Something that is valuable is worth having and wanting. The positive connotation smuggles in my view, an emotive quality that has some vague but real influence in reasoning. Paradoxically, the term values seems to be absorbing the moral content, some moral content. In general usage, values are understood to be matters of subjective opinion on which people can differ. But some, perhaps increasingly many, values do make moral claims that impose constraints on the behavior and on the thinking of people. In short, some values are treated as correct opinions that people must be constrained by, if not compelled to adopt. The tendency that Dewey observed to forget the concrete is precisely what Peter Weston took aim at in his seminal article entitled The Empty Idea of Equality, which is where I got my title, of course. Although equality is derivative, he said, people do not realize that it is derivative. And not realizing it, they allow equality to distort the substance of their decision-making. It gives an aura of revealed truth to whatever substantive values it happens to incorporate by reference. As a consequence, values asserted in the form of equality tend to carry greater and moral and legal weight than they deserve on their merits. This is why arguments in the form of equality invariably place all opposing arguments on the defensive. Weston argued that equality is just a proxy for the particular form of treatment the advocating party wants to claim as worthy of equality protection. The same observation can be made of other charter values like liberty, autonomy, and dignity. But TWU exemplifies the use of equality in the way that Weston deplored. This is exactly, of course, the role that a motivated advocate wants an identified charter value to play in constitutional adjudication. Labeled as a charter value, the idea gains immediate and perhaps winning gravitas. In actuality, the success in labeling of a charter value in a particular case is intended to facilitate result selective reasoning on the part of the decision maker. Let me drill down a bit more. Looked at carefully, the cases bring into sharp relief the subjective nature of decisions invoking charter values and the lack of transparency in the reasoning process leading to their identification and adoption. TWU exemplifies the problem. Invariably, the concept of charter values being used to identify a particular moral commitment that the sponsor asserts is desirable and that should accordingly be given some constitutional weight. But there is never an explanation about why that is. It is simply declared as self-evidently good. And if something is a fundamental moral good, the thought goes, something that all right-thinking people must agree to, then it must proceed from the Charter, which is our national commitment to a consensus of fundamental goods. And if it proceeds from the charter, well, it's a commitment that must both be shared and beyond debate. This is catnip to many decision makers, particularly judges. There's a great joy in donning the moral mantle, something bracingly affirming about finding and labeling a moral commitment as a charter value. Putting it romantically, perhaps, the declarant can be said to be standing midstream in the river of justice that flows out from the charter. It's an intoxicating exercise of judicial power. It's actually an exercise of sovereign power, as I'll explain momentarily. The values approach, charter values approach, excuses the decision maker from the step of justification because all the normative work is done off stage in selecting a charter value in the first place. So, what do lawyers do? They spend their time advocating competing charter values in order to arrange a collision of dignities rather than engaging on the substantive issues and facts. Put bluntly, the term charter value serves in practical terms as a rhetorical device that supplants what should be a transparent analytical process. This is the point made by the TWU dissent. For those who are keeping score at paragraph 309, this is the mischief with TWU. So now I turn to that with that background philosophical discussion having been done. TWU engages an issue first raised in Doré. How does the charter factor into administrative decision making? Now, discretionary decision makers are obliged to take the charter into account. In Slate, the Supreme Court created a convoluted structure for doing that, but the structure did not make practical sense in situations where tribunals heard all of the evidence and all of the argument together, so it was abandoned. Then came Doré, just to remind you of what that was about. At issue was whether the Barreau du Quebec had violated Doré's freedom of expression under 2B of the Charter by penalizing him for criticizing a Superior Court judge. The Quebec Court of Appeal applied the Oakes analysis under Section 1 of the Charter and upheld the penalty. The Supreme Court dismissed Doré's appeal, but took what it called the administrative law approach. Justice Abella stated that the administrative law framework and the Oakes test could be reconciled in the proportionality calculus. In reviewing administrative tribunal decisions that implicates or engages the charter values, a court should move to the proportionality analysis and should not undertake the more rigorous charter analysis. She explained that in applying charter values in the exercise of statutory discretion, an administrative decision maker balances the charter values with the statutory objectives. This is a two-step process in which the decision maker should first consider the statutory objectives. Second, the decision maker should ask how the charter value at issue will best be protected in view of the statutory objectives. The reviewing court must give a margin of appreciation, you've heard those words, or deference to administrative bodies in their balancing of charter values against broader objectives. Doré, when it came out, caused consternation in academic and legal circles, but some delight. Dean Lawrence Austin thought it was a wonderful thing. He still feels the same way, despite all the experience. The confusion about Doré grew with the Supreme Court's later decisions in several religious freedom cases. In Loyola, which was a case about curriculum control in a Catholic high school, the majority, led by Justice Abella, applied Doré, but the minority did not use the analysis at all. And then in Saguenay, a case about whether municipal pre-meeting prayer limited the claimant's rights, none of the judgments refer to Doré. In Tunaxa, the majority did not refer to Doré, while the concurring minority relied on it. And finally, in the Association of Justice Council, the case was not mentioned at all. The majority in TWU, as I said, doubled down on Doré, announcing oddly and perhaps defensively that it was a binding precedent. The Chief Justice accepted the Doré framework, but noted some gaps and omissions, which he then tried to fill. Justice Rowe offered some precisions, as he put it. The dissent, however, expressed fundamental concerns that the framework betrays the promise of our Constitution that rights limitations must be demonstrably justified. They criticize it extensively. There are several difficulties with Doré that have come to the fore in TWU. The first concerns charter values language. The second concerns methodology. And the third concerns, it's a bit nested in the second, is proportionality. So let me start with the new language of charter protections. One difficulty with Doré was that Justice Abella used the language of charter values throughout and made no effort to distinguish charter values from charter rights, even though Doré had directly challenged the Barrow's sanction as an infringement of his charter right to freedom of expression. As I pointed out in E.T. versus Hamilton Wentworth District School Board, confusion results from the failure to make a clear distinction between charter rights and charter values. That decision of mine, along with a decision called Gale, was cited by the 4 judges who did not were not in the majority in TWU, and who expressed concerns about Doré. You might think that was a bad outcome. I think of it as a beachhead. The language in Doré, in TWU, is even looser than in Doré. This is not accidental, since it was deplored by Justice Rowe at 166 and by the dissent. I invite you to consider just what that means. Why would the majority use looser language when it was challenged on that very same issue by the writers in that decision? Was it because the decision was posted too quickly, or because there's a real policy issue, a real policy position being taken? I'm not sure. The majority refers to shared values, in which it included equality, human rights, and democracy. It then went a step further when it invoked fundamental shared values, such as equality. These morphed into something called charter protections. And the progression culminated in this formulation: charter protections dash both rights and values, end quote. The Chief Justice expressed her opposition to the conflation of rights and values. She said, charter values may play a role in defining the scope of rights. It is the right itself, however, that receives protection under the charter. Justice Rowe agreed with the Chief Justice and the dissent. He said, while Doré was intended to clarify the relationship between a charter and administrative action, its reliance on values rather than rights has muddled the application of charter claims in the administrative context. The most extensive treatment was by the dissent. They found that the majority's continued reliance on values protected by the charter as equivalent to rights to be troubling. They agreed with the Chief Justice and Justice Rowe that charter values do not receive independent protection under the charter. They added, resorting to charter values as a counterweight to constitutionalized and judicially defined charter rights is a highly questionable practice. Now, the dissent gave 2 reasons for its concern. First, charter values, unlike charter rights, are the product of a constitutional settlement, are unsourced. Charter values are unsourced. They are therefore entirely the product of the idiosyncrasies of the judicial mind that pronounces them to be so. What is troubling is the imposition of judicially preferred values to limit constitutionally protected rights, including the right to hold other values. Secondly, they say, and relatedly, charter values, as stated by the majority, are amorphous and, just as importantly, undefined, lacking the doctrinal structure which courts have carefully crafted over the past 35 years to give substantive meaning to charter rights, including the right to equality, and to guide their application. Charter values like equality, justice, and dignity become mere rhetorical devices by which courts can give priority to particular moral judgments under the guise of undefined values over other values and over charter rights themselves. It's just a simple, I just want to make sure I haven't skipped something here by mistake. They go on. Take, for example, the majority's preferred value of equality. In our view, without further definition, this is too vague a notion on which to ground a claim to equal treatment in any and all concrete situations, such as admission to law school. The dissent then takes the majority to task. By relying on a sweeping abstraction, the majority avoids actually making explicit its moral judgments, its premises, and the legal authority on which it rests. A value of equality is, therefore, a questionable notion against which to balance the exercise by the TWU community of its charter-protected rights. So much for the new language of charter protections. I now turn to the second problematic aspect of Doré, and that is methodology. The majority says this, the Doré-Loyola formula framework is concerned with ensuring that charter protections are upheld to the fullest possible extent given the statutory objectives within a particular administrative context. Notice that. Fullest extent possible given the statutory objectives, I should say, keep making that same mistake, within a particular administrative context. The language builds on the formula that Justice Abella gave it in Loyola, where she said that under Doré, quote, the discretionary decision maker is required to proportionally balance the charter protections to ensure that they are limited no more than is necessary given the applicable statutory objectives that he or she is obliged to pursue. So, just parsing that language for a second, it suggests that the statutory objectives actually have indefeasible priority over charter rights. And that, of course, is contrary to the Oakes methodology, a point that I made in the Hamilton-Wentworth decision. The dissent picked that up and went further and said this. In other words, under Doré, charter rights are guaranteed only so far as they are consistent with the objectives of the enabling statute. When push comes to shove, statutory objectives, including presumably constitutional statutory objectives, trump the right. But Section 52 of the Constitution Act 1982, which provides for the primacy of the Constitution, suggests to us that it should be the other way around, that rights trump statutory objectives and decisions taken thereunder. That brings me to the third problematic element of Doré, repeated in TWU, and that is the way in which the majority handled the balancing step of the proportionality analysis. The question posed by TWU is whether proportionality analysis is governable or just the raw exercise of judicial power. So, let me set the scene. In Oakes, the court adopted proportionality as a test for determining whether a law limiting a charter right is demonstrably justifiable in a free and democratic society under Section 1 of the Charter. Under the test, the court must determine first whether the objectives of the law or decision that limits rights are pressing and substantial, and second, whether the means by which those objectives are advanced are proportionate. The proportionality analysis asks three questions. First, is a limit rationally connected to the purpose? Second, does a limit minimally impair the right? And third, is there proportionality between the deleterious and salutary effects of the law or decision? A fair argument can be made, and I would make it, that the Oakes framework was intended to structure the proportionality analysis and thereby constrain and discipline courts and administrative tribunals in order to render as intelligible and as transparent as possible the exercise of judicial discretion in the balancing step. Now, without minimizing the importance of the earlier steps in the analysis, any genuine conflict of rights will ultimately be resolved under Section 1 of the Charter at the balancing step of the Oakes test. This is where TWU was decided. In the balancing step, the court is required to consider proportionality as between the deleterious and salutary effects of the law or the decision and determine whether it is just for the law or the decision maker to require some individuals or groups to bear the negative effects of the measures in order to secure the positive effects of the law or decision for the common good. However, the detriments suffered by the common good are usually incommensurable. They're different things, different people, different benefits, and the detriments don't match up or link. There's no common basis or common denominator for evaluating and balancing competing claims between individuals and groups that are negatively affected by the law and any benefits that might accrue to the common good. That's the core problem with the determination of proportionality. But courts sometimes just have to make the call, right? That's what we're supposed to do. So what about that moment of decision in proportionality analysis when the trade-off calculus is made? What's that about? What is the nature of that kind of judicial reasoning? Professor Paul Kahn argues that liberal reason falls short precisely at the moment of decision, because that moment of decision is in reality a pure act of the judicial will. an exercise of political sovereignty in the name of the people. So, time will tell whether the exercise of judicial power will become disciplined by the ordinary rules of intelligibility, adequacy, transparency, accountability, and above all, consistency. Given the Delphic oracle quality of the final balancing decision, proportionality is unusually open to result selectivity and minimally receptive to discipline. TWU exemplifies the problem. Consider this strong statement by the dissent. At the end of the day, however, a court of law, particularly when dealing with claims of constitutionally guaranteed rights, including freedom of religion, must have regard to the legal principles that guide the relationship between citizen and state, between public and private. And those principles exist to protect rights holders from values which the state actor deems to be shared, not to give license to courts to defer or impose those values. For the same reason, a court of law ought not, in our respectful view, to be concerned, as the majority is explicitly concerned, with the public perception of what freedom of religion entails. The role of courts in these cases is not to produce social consensus, but to protect the democratic commitment to live together in peace. Pretty strong language. In effect, saying the majority was result selective in its reasoning. So in TWU, the four outside the majority laid siege to Doré. They agreed that the state actor bears the onus of justifying the limit on the charter right, whether it is a law or decision. The Chief Justice put the onus squarely on the state actor. The dissent strongly agreed. Justice Rowe reached the same decision, but he wondered why the majority was silent on this issue. Why the majority was silent on this issue. Four judges say it's a problem. The majority says nothing. What are we to make of that going forward? The majority asserted that it expected a robust proportionality analysis consistent with administrative law principles, one that works the same justificatory muscles, say that fast, as the Mohs test, not a watered-down version. But the dissent observed, saying so does not make it so. The dissent would apparently abandon Doré and move back to a full Oakes analysis of decisions of administrative bodies. They pointed out that the comments and the scholars cited by the Chief Justice are overwhelmingly critical of Doré, and add that they find troubling the lack of rationale for insisting that on a distinct framework for administrative decisions. As I see it, the majority makes two moves in the proportionality analysis in TWU. First, it minimizes the limits on the charter right at issue, which is freedom of religion. Second, it expands the interpretation of the statutory objectives, which it measures against the limits. So, on the first, the majority minimization of the limit on freedom of religion is seen in several places. It states, the limitation in this case is of minor significance because a mandatory covenant is on the record before us not absolutely required for the religious practice at issue, namely to study law in a Christian learning environment in which people follow certain rules of conduct. It adds that the TWU unit students view studying law in a learning environment infused with the community's religious beliefs as preferred rather than necessary for their spiritual growth. Therefore, the majority asserts it cannot be said that denial of approval is a serious limitation on the rights, religious rights of members of the TWU community, and adds that the decision does not suppress TWU's religious differences. And, this is the critical part, even if it does, the fault is with TWU's religious views, which have the effect of injuring LGBTQ students and their parallel rights to hold and manifest beliefs and opinions of their own. The Chief Justice disagreed. The interference, she said, was not of minor significance. She pointed out that the majority's evaluation is contrary to the court's own jurisprudence and to the accommodation of religious differences in Canadian history. The dissent took a stronger position. The Law Society approval decision represents a profound interference with religious freedom It is a measure that undermines the core character of a lawful religious institution and disrupts the vitality of the community. They thought it was substantially coercive in nature. That was the first move. Second move is this. So reading the statutory objectives expansively, this is where the majority inserts charter protections in its thinking. The legislation provides that it is the object and duty of the Law Society to uphold the public interest in the administration of justice by, among other things, preserving and protecting the rights and freedoms of all persons, and also ensuring the competence of the legal profession. The majority first framed its task this way. The proper inquiry is whether the decision maker has furthered his or her statutory mandate in a manner that is proportionate to the resulting limitation on the charter right. 2 paragraphs later, there's a shift. Approving TWU's proposed law school would not have advanced the relevant statutory objectives, and therefore was not a reasonable possibility that would give effect to charter protections more fully in light of the statutory objectives. So the move, charter right to charter protections, in the calculus that ultimately produces the decision. The majority expresses its 2 key findings in these words. First, the decision advances the Law Society of BC's relevant statutory objectives by maintaining equal access to and diversity in the legal profession. Second, the decision furthers the statutory objective, protecting the public interest in the administration of justice by preserving the rights and freedoms, by preventing the risk of significant harm to LGBTQ people who attend TWU's proposed law school. The minority, the dissent, I should say, challenged the minority's approach. It is important, they said, for a reviewing court to carefully ensure that the objectives put forward by the state actor find their source in the actual grant of authority. Doing so avoids the danger that objectives said to advance a statutory mandate might be invented holus bolus after an infringement is claimed. This is precisely the risk that materialized here, they say. While the majority refers to LSBC's interpretation of the statutory mandate, the referendum decision-making process adopted by the Law Society did not, at the time of the decision, involve any delineation or articulation of any particular statutory objectives. The dissent went on to say, even if the Law Society's statutory mandate had permitted consideration of the broader public interest, concerns that were invoked by the Law Society and the majority, the decision would not be justified, since withholding approval substantially interferes with the TWU's community's freedom of religion, and approving TWU's proposed law school was not against the public interest, so understood. And here is where the dissent makes its own move. Accommodating religious diversity is in the public interest, broadly understood, and approving the proposed law school does not condone discrimination against LGBTQ persons. So what the dissent is doing is advancing a different idea of what pluralism in a liberal democracy entails. They say this: the majority fails to appreciate that the unequal access resulting from the covenant is a function of accommodating religious freedom, which itself advances the public interest by promoting diversity in a liberal pluralist society. They go on. This generous and historically Canadian posture towards religious accommodation stands in stark contrast with the majority's view of the pursuit of statutory objectives as unavoidably limiting the individual freedoms protected by the Charter. This view fundamentally misconceives the role of the state in a multicultural and democratic society. As described by William Galston, in a liberal pluralist regime, the key end is the creation of social space within which individuals and groups can freely pursue their distinctive visions of what gives meaning and worth to human existence. So, the majority goes on, it follows from the foregoing that accommodating diverse beliefs and values is a precondition to secularism and pluralism. Further, it is necessary to ensure that the dignity of all members of society is protected. Tolerance, then, they say, means forbearing and allowing for difference. They then quote Justice Gonthier in a dissenting decision: it is a feeble notion of pluralism that transforms tolerance into mandated approval or acceptance. So, it is sometimes thought that the announcement that one has found a charter value, the plum in the bun, so to speak, wins the case. What the dissent's analysis or approach shows is that there's another way to do it. Another way is to put forward a countervailing narrative. So, what is going on here? Has the court lost its way? Just to remind you again of what the dissent said strongly. A court of law ought not, in our respectful view, to be concerned, as the majority is explicitly concerned, the public perception of what freedom of religion entails. The role of the courts in these cases is not to produce social consensus, but to protect the democratic commitment to live together in peace. So let me just sort of go a little further in a couple of areas. Where does that leave lower courts, the decision itself, when you boil it down, as I have? Where does that leave lower courts, those responsible for judicial review, or appellate courts like the court I'm in? What do we do with this new beast called charter protections, made up of charter rights, charter values, and whatever anyone else can come up that may look the same, whatever somebody else comes up with that looks the same? If someone persuades a tribunal that he has something rooted in a charter protection, does TWU kick in? Who has the onus of proof, respect and justification, given the minority's silence in TWU? You may have heard of our interesting case in Toronto a week or so ago about the restructuring of council. Justice Balababa, who, by the way, taught me constitutional law, came up with a new charter value. He did. It was called effective representation. There it is, new charter value, 101. What did our court do with that? He said, no, right? So, thinking about it though, if we had really taken TWU seriously, we would have had to say, well, there's that charter value. Let's just drive that bus, right? Because that's what we're supposed to do. It's just as good as the ones that are in the charter now. Well, I don't think that that will work in reality. Let me be bold. In my view, the Supreme Court made a mistake in collapsing the two legally distinct concepts of charter rights and charter values in TWU. It will have to walk this back. And it'll be sooner rather than later. Not the result in TWU, it is what it is. But the analysis itself can't work on the ground, in administrative tribunals, or in courts. It just can't. It's completely dysfunctional. So, what I want to do is just make another pitch here for you. If you want to get a deeper understanding of what's going on here, what is the background music that's being played that you can't hear because it's there anyway, I explored the bigger picture in an article I wrote entitled Liberal Pluralism and the Challenge of Religious Diversity, and it was published in 2017 in 79 Supreme Court Law Review, 2nd, page 29. I described 5 overlapping debates at, terrible night. And each of them was engaged in this case by the court. The dissent understood that. The majority, I'm not sure. Maybe they just ignored it. So here are the 5 debates, and I'm not going to go further than just simply list them, and you can go to the article and figure them out. The first debate is this: to what extent should a liberal democracy like Canada accommodate moral diversity that is dissent on morally significant issues? And the question there is it going to be convergence pluralism, where we all end up thinking the same thing? Or is there going to be accommodation pluralism, where we have a notion of live and let live? Our tradition has been live and let live. Where does TWU go with that? The second debate is whether there is a right kind of secularism in liberal democracy. In other words, is secularism about freeing up that social space for religious difference? Or is it about an aggressive destruction of religious presence in society? Benign secularism or aggressive secularism? The third debate is where the border is between public and private spheres. Where is that going to be located? In this particular case, the result of the TWU decision is that the court reached into a private organization called TWU, did not respect the boundary, deliberately did not respect the boundary. Is that a problem for the future? It's an ongoing part of a trend, by the way, in liberal thought, so that's a problem. The fifth debate is about what we must agree on to maintain a viable civil society. That's a core problem. You know, are we going to have what the standard is that I like particularly, and that's William Galston's. Let me just see if I can find the quote because I love it so much. But I think it's exactly where we end up on this. Yeah, I can't find it. He talked about, in the paper that I wrote that I referred to you, about minimal insistence on common things, maximum feasible accommodation. That's the basic idea that he puts forward. I don't know how we can live with real diversity any other way. The sixth debate is over the role of politics in this new world. How much of the politics gets done by politicians and how much of it gets done by courts? Not a small problem. And the seventh debate is about another core question: what is the role of tolerance as a public virtue? People think tolerance is generally a bad thing. It's not, as the dissent says in TWU. It's a necessary thing in a liberal democracy. So I'm done. Any questions, comments, whatever? Stand up and jump all over me, throw things at me. You've eaten your lunch, you can't throw any buns. They're all gone. Should have had a ringer or two, eh? Just come up and ask a question. All right. This is going to be bad.
I've had lots of debates with Lord Sawson, Dean Sawson, about his views on the role of charter values, and I think I understand his position, and I think it deserves some attention. What I think he would say is he's focusing mostly on the obligation that the court has placed on administrative decision makers to consider charter values in their decision making. What he would say is that, I think what he would say is that this will ensure that administrative decision makers who are not sufficiently expert or familiar with charter rights or the charter rights analysis will still make an effort to attend to some of the more general values that are supported by the charter without us demanding of them that they got their charter analysis correct. And so certainly one thing that Lauren argues that I agree with is that we know that most citizens, most people, they have one contact with the state. It's through the administrative state, and it begins and ends there. And if we don't improve the quality of that decision making, we can't really expect that we're going to fix all the problems in judicial review. So that's what I think his view is.
Yeah, no, it's as benign as that. I agree.
Right.
I mean, Lauren and I have chatted as well, although not as obviously as directly as you. What I'm worried about is when you create these things called charter values and they overtake charter rights. Right? That's what I'm concerned about, and that's the invitation that's out there right now. And that's certainly what TWU suggests is a viable approach. That's what concerns me. I don't know where Lauren fits on that. I'm not sure about that. And yeah, I did. Okay, yeah, that's. Anything else? Yeah.
No, I definitely agree it's a bit of an unworkable standard or measure, because as you said, they're ambiguous, and charter values can fall on either side of the argument, and it doesn't give a very clear guide, especially in proportionality analysis. I was just wondering if you could speak a little bit of the role of international law in informing charter values and that in the administrative decision maker making.
Yeah, that's. I've been in a number of panels where people have brought in international law as an effort to try and give some, let's say, some scope and some meaning to what might otherwise be quite sketchy in Canadian terms. in terms of the material we have. I think that's a good idea. What I don't like is when people say this is an enforceable obligation, particularly where Canada hasn't signed on to the particular instrument. For example, I don't think the Canada signed on to anything that's been published by the ILO, right? But
There are a couple of conventions that have been signed on to.
Yeah.
From what I understand, like even signing it doesn't mean anything. You then have to ratify it, and
Right.
then, to be honest, the norms are then only supposed to be incorporated once they've been given statutory life.
Right.
So once they've been included in an actual like law. But Baker kind of jumped over that.
Yeah.
But
Yeah, I mean, I haven't read Baker in years, but it's, to my way of thinking, it's not a bad thing to do, but as soon as you get to the point where it's enforceable, then I have a concern unless it is enforceable through the ordinary mechanisms of law. It's not bad background material. I mean, I wouldn't be upset if it appeared in an authority's brief or it appeared in a footnote to a factum and it was referred to there. It would make sense to me. If somebody wanted to argue it because it made sense, that would be great. That doesn't trouble me at all. And it would be very useful in some cases. Yeah.
You touched on the case relating to the changes to Toronto City Council. I'm wondering if if you see more cases using charter values to nullify, I guess, legislature laws or changes, political issues like that, would you expect more legislatures to try to invoke the notwithstanding clause as the Premier of Ontario has sort of tried to do and then no longer needed to do?
It's an interesting question. I mean, you know, essentially it's a political question. It strikes me that if courts go too far, the reaction will be that legislatures will say, well, we've got to rein these folks in. It's just a natural, and we have these, that's what separation of powers is all about, right? And I think if the borders are starting to get blurred, if people are going too far in one direction or another, you're going to get pushback. This is the first time in a really serious political context where you've had a legislature say, we're not taking that decision from the court, which is an interesting brushback pitch if you think about it in baseball terms. I don't know whether other courts will start to pay a little more attention to that, recognizing that once a government's decided we'll do that, it becomes easier for the next government to do it and so on. Now, the governments are, you know, this is not cost-free. And governments do this at their peril. And it may be that at the end of the day, with everything else, that the Ontario government will discover this was, you know, this might be the straw that broke the camel's back. I don't know, it's a little early. It's very early days, and a lot of things can happen in 4 years. So this may be yesterday's toast by the time the next election rolls around, but maybe not. See? Yeah.
You passed quickly on a point that is very interesting to me, and I was wondering if you could go back a little. It's about where the line is between private and public and how the SEC breached into a private institution.
So in the paper that I suggest you might look at, there's a section in there on this very question, and Paul Kahn is the Yale law professor who goes at this pretty hard. In his view, liberal reason doesn't respect spheres, private and public spheres. You can always think of good reasons to cross over the line. So he says, for example, more and more family law has been removed from the family, more and more of that has become public. So in very many different areas, you see intrusions into what had previously been decided to be public, private, by public influence. Now, one can see that happening across a wide range of areas. Family in particular, this one here in TWU. Education, I think, is certainly a place where that will happen. My guess is you might see it in the future if it's not cut back and not curtailed, not disciplined in an appropriate way. You might see it in relation to religious organizations and their practices. You could see it happening there, you know. So I think it's really, it's the notion of what kind of a society do we want? Do we want to have genuine diversity, or do we want to make everybody exactly the same? This basic choice between convergence pluralism, where pluralism is just a way station on the way to everyone thinking the same, or accommodation pluralism, where we recognize that these differences are permanent. That's the vision. The Supreme Court, the majority doesn't come close to that in its decision, but where it does, it looks like it's pushing for convergence. The minority recognizes the problem and it's pushing for accommodation and real pluralism. So there's the choice, and it's not a choice that's just going to be made by courts. It's also going to be made by political bodies, by people, I mean, by advocates who come forward taking these positions. So far, there's been very little argument on this. I mean, I made this argument in my case in the same-sex marriage reference. Just to be clear, my job was, on that particular case, I was talking about the use of religious properties. I wasn't about the same-sex marriage question. That wasn't my issue. It was about the use of properties. I said to the court, look, you know, if you do this, then there's got to be a conscience rights protection so that religious organizations cannot be forced to let their churches be used and their other properties be used for the celebration of marriages with which they morally disagree. The court agreed with that, and that you'll see that that's in the decision. That was my argument. But I put to them this question. Here is this divergence, and the guy that I brought to their attention was John Gray, an English philosopher who has an entire book called The Two Faces of Liberalism. Nice book. It's a great book. It's a pun, of course. Two Faces of Liberalism. Convergence, accommodation. He says the dominant orthodoxy is convergence, and this is dangerous.
It's so rare that litigators get asked judges questions, so I feel like I can't resist as long as there's no other in the room. I have to say I don't see this criticism in TWU that the court was reaching into the private sphere, because really the only issue is the public certification of the school, right? So that's a statutory blessing, let's say, of the school, which can exist and have many standards as want in private, but if it wants to have a public recognition so that its graduates enter the profession, it's different. And in fact, my understanding is they don't even have to have it. Students could still apply afterwards. The school will sort of be certified, like we aren't for the U.S. bars. We still apply. So I maybe just clarify why it seems an important criticism you're making. Why you see that as having stepped into the private sphere? Because my understanding is that we're only concerned with TWU with the public aspect of their certification.
I don't think so. I mean, if you look at the way in which the dissent carves out the actual statutory obligation of the Law Society, it's to say we're only concerned about the fitness to practice of these people. We're not certifying law schools. We're only certifying the education that's provided in them, right? So we're not going to tell you how to run your school, and we have no authority to tell you how to run your school. That's essentially what the dissent said the Law Society should have done. Now, the Law Society didn't do that. They actually reached in and said, you have to lose that. You have to lose that covenant. So imagine this. Imagine you're a resident in a Catholic hospital. You're going to and you want to be qualified as a doctor. Could you see a medical association saying, well, you have to actually be willing to perform euthanasia or abortions in order to get licensed? I mean, that's the kind of really, micro regulation that I think is deeply problematic. So the private aspect of this, TWU is a private university. It had a specific exemption in the BC Human Rights Code for its practices, like other religious organizations, and yet the Supreme Court majority did not even advert to that particular aspect of the code, but went in there and said, you got to change that. Precisely contrary to what the code itself had set up in recognizing this organization's private nature. So I think, I've only said a little bit here. You should take a look at the dissent. They really do a good job of explaining how it is that it's an important protection. Yeah.
I just have a question about, this made me think about it, the way that you said that the structure of the framework right now is that anyone could sort of assert their right and that the court or the administrative tribunal has to follow through with the process. I just see a bit of a discord between that and then the minority. I mean, the dissent in this case seemed to sort of take Trinity Western's assertion of their religious freedom right at its value as whatever the university said it was. And I think the other decisions tended to challenge that a little bit, to question exactly what about the school's religious freedom was being asserted as part of that religious freedom. And I'm wondering, on one hand,
anyone could assert a charter right in an administrative tribunal, and then the court they have to follow through with whatever that person asserts, yet you say that the dissent's acceptance of the Trinity Western's right without questioning is okay. I see those as
Well, just in terms of freedom of religion, if I may, the precedent is Anselm, right? So you need to show that the particular nature of your religious attachment is there. In other words, it's a nexus with religious value. You sincerely believe it. That's all required. Nothing more than that. It's a very low bar test. What the majority does in TWU is says, well, it's not absolutely required, right? So therefore, it's not really effective. But that's not the way in which we interpret our religious rights. We haven't so far, at least in Canada. We've said we're going to leave it to religious organizations and to individuals to define for themselves what they think is religious. And we're going to take what they say at face value. The only thing we're going to ask is that they establish their sincerity. Nobody argued, not even the majority, that TWU wasn't putting forward a sincere case. The problem was it started to cut into, and the majority, contrary to Anselm and other decisions, actually started to say, this is not really serious because it isn't absolutely required. Well, I'm a Catholic, right? According to the canon law, I'm only required to go to communion once a year, right? So if a law came along and said I could only go to communion once a year, would it interfere with my religious freedom? When my normal practices go every week? The answer to that is, of course, yes, right? So at some point or other, we have to let religions define themselves in their own obligations. And we have to take that at face value unless we think that it's being put forward for an improper purpose and it's not really sincere. That's a fair question, and that deserves to be asked when it's raised.
Do you think the removal of the covenant after the fact maybe questions that a little bit?
Pardon me?
The fact that they removed the covenant recently, the requirement for the covenant, do you think it brings into question the case that they put forward about the...
Well, I mean, okay, so now you see the outcome of that's the outcome of the decision, right? So you say, freedom, what we have now is state power requiring a change in a religious viewpoint by a particular organization. Exactly the opposite of what freedom of religion is intended to protect. The outcome is exactly the opposite of that. So now a religious organization is required to change its practice, and it's doing that, not because it's not sincere about its practice, but because it has to if it wants to have a law school. And it really wants to have a law school. So it's got to make a choice here. And normally freedom of religion doesn't force religions to make choices like that. It's exactly what freedom of religion is designed to protect against. But there it is. Yeah.
I guess kind of on the same topic, I'm wondering how you would frame the covenant as kind of a freedom of religion thing, where to me it's prohibiting certain actions, but it's not. Sorry, it's kind of hard to explain. In your example with the medical resident, you say you were talking about how a medical resident might have to perform an abortion or whatever, or euthanasia, and that would be a clear infringement of kind of their freedom of religion. They would be forced to do something, whereas the covenant doesn't necessarily force somebody to do something, rather it prohibits somebody from doing something. Does that kind of make sense? So in my eyes, even if you don't have to sign the covenant, it doesn't mean that you would then have to engage in sexual activity outside of heterosexual marriage, right? Rather, the covenant prohibits you from doing this thing that is supposedly against their religious position. But it's not. Does that kind of make sense?
So, I mean, forcing somebody to do something positively is way worse than preventing. I'm not quite sure I understand that.
Well, the example I was thinking of when you brought it up would be more like when we refused to certify a Catholic hospital, where they made the doctors that they trained sign a covenant to never perform an abortion or never perform euthanasia.
Yeah,
And
that was
then I
better.
think there may be an issue there, whether that being inconsistent with what the charter has required.
An interesting example. I have to think about that, but my answer would be that that would be inconsistent with freedom of religion, and therefore contrary to the charter. Yeah.
But I just, at this point, and I have to
So,
follow.
just a second. I once had a debate with Lorraine Weiner over this very question, right? She said, we were chatting, I was a lawyer at the time, we were at U of T, and she was at a conference, and she came in and said, it's really terrible, I've just discovered something. And I said, what's that? She said, St. Michael's Hospital does not have morning after pills. And I said, yeah, it's a Catholic hospital, it doesn't believe in abortion, it thinks that morning after pills cause abortions. She said, well, that's horrible. I said, well, why is it horrible? She said, well, they should be required to. And I said, well, you can walk down the street to a pharmacy and get one of those. Why should a Catholic hospital be forced to make this available when it's contrary to its particular ethics? She had no answer for that. She just thought that was what should happen. Sorry, you were asking?
Yeah, I find it weird that like we've sort of elevated certain beliefs, get certain protection under freedom of religion, especially when it comes to things like education and health. Like, if I show up at a hospital and if it's a completely private hospital, then I get it. If you're doing a public function, if I go to a doctor and they're like, I'm not even going to refer you to get an abortion, like, I would have a problem with that. And then there are other behaviors which may be sincerely held but are not part of a traditional religious form, and I'm thinking of RV Clay and the marijuana Clay case, don't receive the same type of protection in our retort or in our courts. Like, I just find, but I guess religion is under attack in this case too, so. I don't know where I'm going with that, never mind.
Okay, thank you. Anyone else? Yes.
Well, I guess just to speak on, to add on to that point as well, because I think it's interesting. I think that we could also suggest that there could also be a legitimate fear that, realistically, not everyone lives in Montreal or in Toronto, where, every health service is relatively accessible. I think that there has to be some sort of consideration, at least, for places where, maybe you can't just walk to a pharmacy and get a morning after pill, because the only place you can go is the nearest hospital. Now, does that mean that the government should have an obligation to open different places where people can get medical help, and every community needs to have one of these places? I don't think we'd be able to enforce a positive obligation on the government, but maybe that would have to become the remedy if certain things relating to health weren't made to be accessible. My issue with charter values is that, for example, you addressed that book, The Two Faces of Liberalism. Under Section 1, an infringement can be justified if it fits within the principles of a free, democratic, etc. government, and I think that the big point of contention is that if we start abusing of enumerations of charter values, but we don't have Section 1 to refer to because it doesn't exist within administrative review, right, under Doré, then at that point we don't, or am I wrong going on that? I don't know.
No, just to be clear, I think administrative tribunals should apply the charter, right?
Okay.
I never said anything to the contrary. I think that's what they should do. What I'm saying is it should be a proper charter analysis in relation to Oaks. I think the dissent is right on this. Okay, that's all I'm saying. I'm not. I don't say anything more than that. I'm not saying administrative tribunals should not do charter analysis. They must. It's part of the law of the land. I have no trouble with that at all. Anyone else? Well, thank you very much. It was lots of fun. Questions?